We are now in the second part of the class, the sources of law of contract. In Nigeria specifically, we know that Nigeria was colonized by Britain, and because of that past, we have adopted some laws of contract from Britain. So this one source of law of contract in Nigeria is the received English law prior to January 1st, 1900. So we have all those laws that were in England as at January 1, 1900. We received them. As with most terms and concepts in law, it is difficult to find a succinct, generally acceptable definition. So let us move straight to the definition of law of contract. I would align myself with Sagay's definition that contract is an agreement enforceable by law. Contract is an agreement between parties first. So parties must agree. It's important that parties agree. That is why later on you see that some vitiating elements of contract is undue influence and duress. So if I have not agreed, if I was forced into it, it's not a contract. So first, it's an agreement by parties that sets out the obligations expected of those parties, their legal rights and obligations. It is set out in that agreement. And then the law recognizes those sets of agreements, those obligations, the law recognizes them and will enforce it. Contract by Sagay, it's an agreement by parties setting out the legal rights and obligations of those parties that the law recognizes and will enforce. Look at it, if we break it in one part. First, contract is a set of agreement by parties. So there must be at least more than one person in a contract. We're going to look at classifications of contract later. It's also an agreement, like I said before. Now, what next? That agreement sets out the legal obligation and rights of those parties. The agreement sets it out. And that agreement also is recognized by law. The law recognizes it and then will enforce it. That is, when I say enforce, I mean when there are issues, if a party refuses to act in line. I know why I'm using these terms now because I assume that you are just coming into the law of contract. If a party refuses to perform their own part of the contract, that is, do what they have set out to do in the contract, the law will enforce that contract against that party. That is, the law would make you do that which you're supposed to do or pay some form of damages for not doing that which you're supposed to do. That is basically what a contract is. I will also put it out there on your screen to say that they are a set of obligations that are imposed by parties, not generally by law. That is, if we look at the law of tort, criminal law, we find out that there is an obligation on me from criminal law not to kill anyone. There are obligations imposed upon me by law, but contract is usually obligations, sets of obligations imposed upon individuals by themselves generally.